Welcome to International Trade Minute, quick-fire trade news, brought to you by Reidel Law Firm. This podcast is your go-to source for the latest updates in international trade law and policy, tailored specifically for industry practitioners. In today's episode, we'll explore a series of significant developments impacting the trade landscape. From a high-stakes lawsuit involving Seko Customs Brokerage to the ongoing G7 negotiations on repurposing seized Russian assets for Ukraine, we've got plenty of pivotal updates to discuss. We'll also cover the heightened scrutiny by CBP on consignee addresses and product descriptions, as well as a recent BIS fine on a Texas-based company for anti-boycott violations. Stay tuned for an insightful and engaging session designed to keep you informed and ahead in the complex world of international trade.
Seko Customs Brokerage has recently taken legal action to challenge its suspension from the Type 86 entry pilot program and the Customs Trade Partnership Against Terrorism, commonly referred to as CT-PAT. The suspension, initiated by U.S. Customs and Border Protection, CBP, has raised significant concerns within the industry, primarily because Seko contends that the process was marked by a lack of adequate notice and informational transparency. According to Seko, the suspension, which commenced on May 27th, was abrupt and allegedly violated administrative procedural requirements. The company argues that CBP failed to provide sufficient specifics about the non-compliant filings that led to the suspension, thereby compromising Seko's ability to respond effectively and implement remedial measures. Furthermore, Seko alleges that CBP's actions have not only caused severe monetary losses, but have also inflicted significant reputational damage on the company. Seko claims that since 2019, it has been a prominent player in the de minimis entry space, leveraging the efficiencies of Type 86 filings. The company asserts that the suspension has resulted in a substantial portion of its Section 321 shipments shifting to competitors who remain eligible to file Type 86 entries. This, Seko states, has severely disrupted its operational efficiencies and client relationships, particularly within the e-commerce sector. In its lawsuit, Seko is seeking injunctive relief from the Court of International Trade, aiming to compel CBP to reinstate its participation in the Type 86 program, as well as CT-PAT. The company has highlighted that CBP's procedural shortcomings, including the agency's inadequate response to Seko's proposed corrective action plan and the redacted nature of the audit findings, have unfairly impeded its ability to comply with regulatory requirements. Seko also argues that its Fifth Amendment right to due process was infringed upon by the lack of detailed information and the absence of an opportunity to address the alleged violations before the suspension was enacted. Additionally, Seko contends that an internal CBP memo, which was leaked, has further tarnished its reputation by indicating its suspension, an act Seko believes was unlawful and damaging. Seko's appeal to the court underscores the necessity for a transparent and fair administrative process, especially when regulatory actions have far-reaching implications on a company's financial standing and industry reputation. The outcome of this lawsuit could set a significant precedent in how similar cases are handled and may influence the future conduct of CBP and other regulatory bodies in the enforcement of trade compliance programs. In an effort to address the ongoing crisis in Ukraine, the Group of 7 nations, which includes the United States, are currently engaged in negotiations to repurpose seized Russian assets to bolster Ukraine's defense efforts. Dalip Singh, a National Security Council official in the U.S., provided intriguing insights into these discussions. He explained that while the countries have not yet reached a consensus, the potential mobilization of funds is substantial, with estimates suggesting as much as $50 billion could be directed towards supporting Ukraine in the immediate term. Singh further noted that this financial assistance could multiply significantly over time, amplifying its impact. However, the path to this agreement is fraught with legal complexities. Different G7 members face varying legislative landscapes, making the uniform repurposing of seized assets a challenging feat. For instance, while U.S. legislation, such as the Rebuilding Economic Prosperity and Opportunity for Ukrainians Act, facilitates the seizure and reallocation of Russian assets, other G7 nations do not yet have equivalent legal provisions. The urgency of the situation is well understood among the G7 members, as Singh highlighted the dire conditions on the ground and the disproportionate burden currently borne by the United States in terms of available assets. The U.S. holds only about $5 billion of the estimated over $300 billion in immobilized Russian reserves, underscoring the necessity for collective action to significantly aid Ukraine. In addition to financial support, the possibility of broadening sanctions and export controls on Russia to include more stringent measures against Chinese entities that might be aiding the Russian military has been discussed. Singh's remarks hinted at upcoming announcements from the G7, indicating a potential increase in sanctions aimed at curtailing Russia's military capabilities, what he described as disarming the Russian war machine. The complexities of crafting effective export controls were also addressed. Singh emphasized the need for a strategic approach, identifying technologies that are foundational to U.S. national security and ensuring these are not easily substituted by adversaries through third-party countries. Forming coalitions with allies to enforce these controls will be imperative, as will anticipating and countering potential retaliatory measures from the targeted nations. As negotiations proceed, Singh depicted the current period as one of intense geopolitical competition, utilizing economic statecraft tools such as sanctions, export controls, and investment restrictions with unprecedented frequency and intensity. In this context, the cohesive and proactive stance of G7 nations remains vital for supporting Ukraine and maintaining strategic stability. Stay tuned to see how these international negotiations evolve and the specific measures the G7 will implement in response to this ongoing conflict. Flexport has reported some significant updates regarding the scrutiny being applied by CBP, particularly concerning false consignee addresses and vague product descriptions. This development is especially pertinent for entries under Type 86, which is a pilot program designed to facilitate faster clearance for de minimis packages. Marcus Eman, the Senior Global Customs Manager at Flexport, highlighted that while CBP has always had rules about the proper descriptions of items, there has been a noticeable increase in the rejections of entries over vague descriptors. Importers are finding that descriptions such as women's dresses are now more likely to be flagged, whereas more specific terms like polyester woven dress are yielding better results. Furthermore, Tom Gould, Vice President of Global Customs and Trade at Flexport, mentioned that CBP is actively working on software that can identify words frequently used in vague descriptions, such as samples, product numbers without descriptions, and generic terms like wearing apparel. This software aims to streamline the identification of non-compliant entries. An informal poll conducted during a recent Flexport webinar revealed some insightful statistics. About 35% of participants currently file Type 86 entries, 32% are considering it, and 3% have ceased filing them. For those who don't file, 70% stated they need to learn more about the process, 9% are concerned about CBP enforcement, and another 9% found it incompatible with their business model. These figures suggest a significant interest in and dependence on the Type 86 programs and the need for ongoing education about compliance. Additionally, CBP is expanding its vigilance to other modes of entry beyond Type 86. For instance, some goods such as sunglasses and bug spray, which are often subject to partner government agency requirements, may face different or additional scrutiny under this intensified oversight. Tom Gould advises that customs brokers should take several proactive steps to ensure compliance. This includes verifying the accuracy of consignee addresses and ensuring no shipment exceeds the $800 threshold from different sellers by adding up multiple shipments. Moreover, brokers should communicate clearly with their customers to ensure adherence to partner government agency requirements and flag any potentially non-compliant shipments. Lastly, Gould shared an insight from a recent CBP conference, noting that the frequency of checks and examinations on Type 86 entries is likely to increase. His advice reflects the ongoing evolution of CBP's approach to ensuring compliance and stopping illicit trade, with a call for brokers to remain vigilant and prepared for these heightened scrutiny measures. In conclusion, these updates emphasize the importance for customs brokers and importers to adapt to CBP's evolving requirements by maintaining precise, accurate, and compliant shipment descriptions and consignee information, ensuring smoother and faster clearance under the Type 86 program. The Bureau of Industry and Security, BIS, has fined Airbus DS Government Solutions $44,750 for failing to report a boycott request and for certifying that its products were not of Israeli origin. This incident took place during a 2019 trade show in Kuwait, where the company used a freight forwarder to ship its products. BIS stated that Airbus DS Government Solutions issued a commercial invoice and packing list to certify the goods weren't made in Israel, in violation of U.S. anti-boycott laws. Matthew Axelrod, the top BIS export enforcement official, reiterated the necessity for companies to be vigilant when examining transaction documents to ensure compliance with anti-boycott regulations. He highlighted that these rules apply equally even when requests come from other U.S. companies. Airbus DS Government Solutions voluntarily disclosed and admitted to the violations. In response, the company has stopped working with the implicated vendor and reinforced its export compliance program to prevent future lapses. This enforcement action underscores the critical importance of rigorous adherence to anti-boycott regulations to maintain the integrity of international trade practices. That wraps up this episode of International Trade Minute, Quickfire Trade News. Remember, staying informed and compliant is key to navigating the complexities of international trade. With an ever-evolving landscape, keeping abreast of the latest developments ensures that you can effectively manage your operations and mitigate risks. Thank you for tuning in, and special thanks to Reidel Law Firm for sponsoring today's podcast. Your support allows us to bring you concise, impactful updates each week, helping you stay ahead in the realm of international trade law and policy. Join us next week for more updates on the regulations, policies, and legal proceedings that shape our industry. We aim to provide you with the essential news you need to make informed decisions promptly. Have a great day. And until next time, keep navigating the currents of international trade with precision and insight.